sure that we are meeting the needs of the eligibility of those in need. Mr. Speaker, I commend this bill to the House.
I call Dennis O'Rourke.
Thank you, Mr. Speaker. I'm afraid I would have to say that the bill as introduced was a thoughtless attack on the legal aid system in New Zealand. It was basically a quest to save money without regard to the legal aid needs of people who cannot afford to pay a lawyer. The government was willing to do serious damage to the system, and in criminal legal aid, people with less serious charges to face but still needing a defence would have had to defend themselves, often with disastrous consequences for justice and for good court procedure. The availability of aid for lawyers for the child and for youth advocates would also have been seriously reduced, and proceedings for which aid could be granted could have been removed through legislation. Predictably, Mr. Speaker, there were a large number of submissions on the bill, especially in respect of those matters. To her credit, the Minister has listened to the chorus of protest and has shown a willingness to amend the bill. And in October, she introduced SOP 134 to undo some of the harm that the bill would have done. And that SOP does indeed address many of those matters. Firstly, and in particular, it does retain the existing appointment framework for lawyers for the child. Point of order, Mr. Speaker. Point of order.
Point of order, Dennis O'Rourke.
There seem to be a lot of interjections from one side of the House to the other.
Order. I'm the judge of that. Dennis O'Rourke.
Thank you, Mr. Speaker. I hope that the members on both sides of the House will observe the rule that if there is to be interjections, then please, by all means, address them to me, but not to each other. Mr. Speaker, that was the first issue that was addressed. And I agree, in fact, that the lawyers for the child and youth advocates were indeed absolutely necessary. Those people cannot represent themselves, and the courts would be constrained in delivering justice without assistance of lawyers. The second issue is this: the removal of the proposal to use order in council to alter the proceedings which would be eligible for legal aid, something which is called a Henry VIII clause, was good to see gone. Removing tighter financial means for the less serious criminal cases has also been removed, and I also approve of that. And some common sense stuff like removing household goods from the calculation of eligibility for legal aid is just that, a good common sense provision. Now, the Minister has indicated changes to be introduced in regulations, and New Zealand First approves of the reduction of $100 to $50. We think that's fair and sensible. Also, we are glad to see the provision which says that interest would not be charged for the first 6 months on legal aid debts. We do think, however, that it would be better still if no interest was charged on legal aid debts. The supplementary order paper also introduced several new positions, including increased ability to refuse to grant civil or family legal aid in certain circumstances. Now, Mr. Speaker, that's being worked through still, through the Family Courts Bill, and again there are many protests. So we'll wait and see how that turns out. The point is that it's another attack on the accessibility of people to lawyers, to legal representation in this country. I did want to comment on the provision which requires an applicant in arrears for repayments on previous legal aid debts being subject to a test under which they would have legal aid for a proceeding to be removed. Now, the point about that is not a fair and proper legal aid system. That provision should have been removed altogether. if there is any concern about people not paying their legal aid bills,
Order.
then that is better.
Sorry to interrupt the member. There can be no order. There can be no reference to the public in the gallery. Dennis O'Rourke.
Thank you, Mr. Speaker. If there is any genuine concern about people not paying their legal aid debts, then that can be addressed better in other ways, not by removing legal aid altogether. That is not consistent with the purposes of the Act, and that provision should have been removed altogether. The members opposite may laugh about that, but in fact there are people out there who will not laugh when they are denied legal representation by a provision which is completely against the purposes of the Act. And another issue, Mr. Speaker, is this: charging interest on legal aid debt. Now, I'm glad that the committee recommended what I asked them to do, which is to delay the imposition of interest for 6 months. It would have been better, however, if interest on legal aid debt was removed altogether. And Clause 12 of the bill, as introduced, requires required payment of legal aid from the beginning. 6 months is a good provision, but better still would be no legal aid, no interest on legal aid at all. And the reason for that is simply that too many low-income people will be affected by that provision. It doesn't provide any real encouragement for those people to repay their debt sooner. In fact, many may give up. And a free of interest provision, I believe, is a proper government contribution to legal aid in this country, and interest should not be required at all. Now, I also approve, however, of the reimbursement of costs for lodging a caveat over property to secure legal aid debts. Now, that's already done, in fact, as a condition of the grant. However, it's perfectly proper, I think, for the new legislation here to put that into law, to regularise that. Now, concerning additional eligibility for legal aid, New Zealand First disagrees with allowing the Commissioner to refuse legal aid, as I've said, if there are arrears. We think that is very unfair. Mr. Speaker, overall, we think that this bill, the SOP, amends this bill to improve it very significantly. But in the end, it hasn't done enough to address some of the problems, especially those which I have mentioned. So taken together with the availability of legal assistance, which is already not easy to get in this country, and to the proposals for the family court legislation which are going through at the moment, the problems of this bill mean that New Zealand First cannot support it. The bill's genesis was penny pinching. There have been some good amendments now proposed, but none of them go far enough to make this good law or a bill which we could support.
I call Dr. Jackie Blue.
Thank you, Mr. Speaker. I'm delighted to speak to the Legal Assistance Amendment Bill, the second reading.